morning. We are now starting with the first panel, which I think not be more timely regarding the topic of the discussion, but also considering all the keynotes that we just heard, where I think every keynote speaker mentioned at least once the matter of face recognition. I have here a panel with excellent speakers on this topic, and you will find in this panel discussion a broad pool of different opinions on the matter of face recognition. I just wanted to start by saying that, of course, we have a concentration in this conference on the law enforcement topic and also on the European Union, but face recognition is a topic that is globally discussed. I just wanted to mention the movie Predictive Bias, which some of you might have seen, that is about artificial intelligence and face recognition. There has been a US class action suit against Facebook that is ongoing, and that is about the automated photo labeling. We had in the last Eden conference Professor Miyashita from the University of Tokyo, who told us about the case in Japan, where bookstores have a bad face database and employed with face recognition in the chains of the bookstore, and where facial features are used actually to identify potential customers who intend not to pay for a book. So we are looking here at the global debate on the use of face recognition. This panel could not be more on time, since at the beginning of this month, and I think some of the keynote speakers mentioned this, the European Parliament called for a ban on police use of facial recognition in public places, a ban on predictive policing, which means actually the use of artificial intelligence tools in the hope of profiling potential criminals before a crime is even committed. You heard the European Data Protection Supervisor in his keynote, which I think also for this panel is quite relevant. And what he actually said in his opening remarks to the Eden conference is that although the EDPS recognizes that the ban to the use of facial recognition technology in publicly accessible areas is the rule, he sees also room for exceptions. And such exceptions shall be treated, and I quote him, limited and restricted, and the processing shall exist only for clearly set purposes or for the limits of these purposes. So I think this is quite an interesting point, and I believe also a fine-tuning of the opinion of the European Data Protection Supervisor on this topic, and that is for sure very interesting for our debate. So it's my honor to invite the first speaker for this panel, Assistant Professor for Public Law at the University of the Côte d'Azur Nice, Caroline Lequesne-Roth, for providing us a first overview and introduction in the topic of face recognition technology and the use by law enforcement. Please, Caroline. Please, yeah. Should be there.
Okay, yeah. Nice. So good morning, and thank you to the organizer and for the invitation. So it's an honor and a pleasure to be here. So as it was said, I'm a law professor. So I'm interested in legal aspects of technology surveillance, and today I will present you what is the actual legal framework of facial recognition, and also its flows and its perspective regarding the Artificial Intelligence Act draft. But before that, I think what is really important is to set the context somehow, because there's a lot of fantasy. There are a lot of fantasies about facial recognition in Europe, fed by some very worrisome example from US and from China, which have particularly not the same legal environment. So I will first give you some insight, some overview of the use of facial recognition especially in spaces accessible to public, and then I will talk about the legal framework. So, last spring, I've been requested by the Urban Agenda to realize a study about facial recognition and surveillance technology in Europe. And in order to do so, I have to identify which were the use cases. Actually, there were 53 use cases in Europe. Most of them were experiments. And as you can see, most of them describe the use of facial recognition in airports to ease cross-border. For the law enforcement perspective, the use cases are much less widespread, I would say. And as you can see also on the first figures, not all the experiments concerning law enforcement were carried out. Some were about to, but it's not really clear if they will be carried out or not. Some have been completed already, but without any perspective of rolling out. And there's clearly a lack of transparencies on these experiments. So what we can say is that these figures shows a big discrepancies between the willingness of police forces that I have met and these figures, because actually facial recognition is not really developed in Europe. And I think one of the explanation of that discrepancies is probably the legal framework, because actually we don't have in Europe a right legal basis to roll out facial recognition. So, concerning facial recognition, as has been already said, we have two main legislation whose application depends on the European, the purpose of the data process. We have the law enforcement directive for the purpose of prevention, investigation, detection, and prosecution of criminal offenses, and any other personal data processing falls under GDPR. But both are interesting because most of the experiment relies also on GDPR. So in those texts, the biometric data, which is actually the main data used for facial recognition, is the processing of that kind of data is prohibited or only allowed where strictly necessary. But the two legislations share some common exception. So we'll see them one by one, but these exceptions are when the vital interest of the person is at stake, for the data which has been manifestly made public by the person, the consent concerning GDPR, and the legal exception. So the vital interest could have been an interesting legal basis regarding to the COVID context, because especially in France, where I come from, the facial recognition turned out as a way to fight against the spread of the virus. So we could have used this legal basis to roll out facial recognition, but actually when we read the recital of GDPR and also the EDPB guidelines, we understand that it does not provide a legal basis because the interpretation is very narrow. So the other exception, the data that were manifestly made public, this is also an interesting exception, but the problem is that it opened the Pandora box, because almost everyone has a photo of himself on the social media, but that doesn't mean that you want your biometric data be used in that kind of context. So This exception has also been construed very strictly. And what is interesting is that in the Clearview cases, the authority of Cannada, which has to deal also with the problem, with the issue, said that actually we can't use that kind of exception to rule out facial recognition. And which is this case is really interesting because we have almost the same legislation in Europe. The third is the consent. It's not for a legal basis for law enforcement purpose, but as I said, it could be for experiments, and especially in the city of Nice, where I come from, when we have this experiment with the police forces, they use the consent as a legal basis. But again, it's not really suitable for the law enforcement purpose, because it has to meet the condition of the Article 7, which is strictly construed again, and it's impossible to put in place for identification aspects. So it's not either a good legal basis. So the only one left is the legal exception, when the law authorizes such a processing, when there's a national substantial interest in GDPR, or when it's strictly necessary in the law enforcement directive. Unfortunately, the problem today is that we don't have that kind of legislation. No country has adopted such a system, such a legislation, and there is no European law that also authorize that. So at the moment, we are in a very difficult situation because it led to some very different appreciation, interpretation from Data Protection Authority. Italy was in the favorable cases until last spring, but they prohibited some experiment too. So at the moment, there's some different appreciation of it, and it's raised a lot of problem and insecurity for all the players. Fortunately, the European Commission, through his draft on Artificial Intelligence Act, put some new steps in order to go forward in the situation, because all the players are in a difficult situation at that time. Even the police authority, because when they wanted to use that kind of technology in some very specific context, even when they work with the Data Protection Authority, they never managed to have some clear information about what they have to do, what are the requirements in order to roll out such a system. So what brings the Artificial Intelligence Act is the first idea of what could be a framework for the use of facial recognition for law enforcement purpose. So they call it in the draft remote biometric identification. So it concerns not only facial recognition but all kind of identification processing, and they propose some new obligation for providers and users. First, this draft is about what will be the obligation for the users, so the police authority, especially when they want to use facial recognition. So the draft announced that facial recognition in real time will be, for purpose of law enforcement, will be prohibited, but it also mentioned some exceptions, 3 broad exceptions that allow to use it in some very specific context. So these exceptions, which are at the left of the screen, allows the use of facial recognition for the detection, the localization, the identification, or prosecution of a perpetrator or suspect who commits one of the 32 categories of criminal offenses listed in the framework decision of the European arrest warrant. So it's a very broad exception, and some may wonder whether they had anything new about what we have actually concerning in the law enforcement directive. Actually, there are two things interesting. First of all, some uses of facial recognition are actually prohibited, like the use of real-time facial recognition, which are not in the list, like for an event to ease the situation, to ease the flow of the public, for instance. But moreover, and most importantly, it introduced an authorization procedure granted by either a judicial authority or an independent administration authority, actually the data protection authority. This is something really important. This is a huge step because it will help all the players to build the experiment, to build the rolling out, thinking about security concern and also fundamental rights concerned. I think thanks to this procedure, we will have standards, we will have some clear indication about what we can do and what we can't. And the authorization will be granted on the basis of the Data Protection Impact Assessment, DPAA, which was not clearly mandatory until now for facial recognition. So this is also a huge step in Europe. Concerning the providers, there are some remarkable novelties. First, these they will have some requirement for them. These requirements will concern all the system used by the law enforcement policies. It will help to share the burden somehow with the providers and not only on the users, which is the case actually. All the systems are concerned and subject to the following requirement: an adequate risk assessment, high quality of the data sets to minimize the discrimination outcome, logging of activity, which is a measure of traceability, an appropriate human oversight, a high level of robustness and accuracy, which are many elements which were not clear at the moment, but which will help to have some transparency, accountability, accuracy system used by the police forces. There's also the fact that these tools will be subject to stricter conformity assessment procedures than those other of higher risk. That means that the European legislators understand that what is at stake for law enforcement is particularly important regarding our democratical principle. So this is a huge step. This would be a huge step in Europe. At the moment, it has not been adopted, and the debate is not over. As it had been said, the European Parliament calls for a broader ban. The European Supervisor on Data Protection is also for this broader ban. But I think that we would make a nice step, and to continue in that right direction, we have to think about what will be the standard, how we'll train agents, because it's not in the text too, in order to reinforce the human right protection and the data protection in this text. So I will stop there to leave the place for discussion after that. I hope it was fine. Thank you.
So thanks again, Caroline, for giving us the introductory remarks for this panel. I think I liked in particular your overview that you gave about the AI Act and also the proportionality that has to come later on in implementing the legislation. So thanks for this. It's now my pleasure to announce to you the next speaker, Mr. Luigi Cannada Bartoli. Mr. Bartoli comes from the Garante, the Italian Data Protection Authority, which I think has one of the nicest offices in Rome, or at least very famous offices in Rome. Mr. Cannada Bartoli is for the second time now the director of the Study and Research Department at the Garante, the Italian Data Protection Authority. Before that, he was long years director of Legal and Justice Affairs Department, also at the Garante, which is inter alia competent for supervising data processing operations by the police. Please, the floor is yours.
Thank you, Chair, and thank you for inviting me and giving me the possibility to be in front of this audience and in this panel, although it's not very easy to take the floor after this presentation so rich and so clear. When I was 11, the teacher told us in the classroom that everybody at 40 have the face that they deserve. I didn't understand this, but now I do, maybe because I'm more close to the 40 than to 30 years. In the same time, I saw a movie, a Western, where the Indian didn't want to be taken a photograph because he was afraid that the photo could steal his soul. I found this idea very, very naive, and I laugh about that. The same idea you find, a similar idea you find in this book written by a doctor who lived in Turin and was confined by the fascist police in a small village in the southern Italy. And he talks about this woman. He said, so Julia was willing to do anything for me, but when I asked her to stand for a portrait, she didn't want, because there is something magic in this idea that you take out an image from a person, and she didn't want to undergo to this. Sorry. And really this idea of something magic, I think, is important when we think what is the special regime of biometric data, and namely about face recognition, because these are data so important and so relevant that they confer a very great power to the one that detains them. This is, I think, to be considered very well when we think about this data. And in a recent decision, Garante gave a negative opinion in a data processing impact assessment about a system of facial recognition in open air by the police. And as you can see, the system had the possibility to compare people in plein air space with a watch list of up to 10,000 people. And there is an alert when a face of somebody in the area is similar to a face in the watch list. And Garante found that everything must be examined very, very carefully, and two levels of concern: a level of concern regarding the data subject and a level of concern regarding the general democracy. I mean, this idea of mass surveillance, because most of people whose faces are kept are not of interest for the police. That is the point. So it's possible to go from an individual surveillance to a mass surveillance. And this Garante found that there is no legal basis for that. I think, and I hope the decision is true, but I think what is more important is to consider the reason why and the possible effect of this data processing on the general situation of the democracy. And these are the rules the Garante said that must be taken into account in order to allow this possibility of data processing, and namely the criteria for identifying the person in the watch list that is not neutral, the consequence of false positives, and also the possibility that the system functions very well also concerning people in ethnical minorities, because, you know, to be a false positive can be very, very detrimental for a subject, and so the system must be also from the technical point of view very well done. And you find the same concern in Council of Europe, opinion, the consultative committee on the European 108, and in a work of CNIL, that is the French Data Protection Authority. And the CNIL says, you see, des glissements progressifs conduisent à un changement de société non anticipé et non souhaité, et qu'on se trouve un jour devant un fait accompli. So, this is very important. And another important decision I just will mention is one of the Court of Appeal of English and Wales overturning the decision of the High Court. But I think it's very important, this idea of glissement progressif. You find it very well shaped in a work in Our Law Review 2003 that gives the idea that when you begin, if you are on a slippery slope, you know the way things begin, but you don't know, you cannot predict how the things end, and it's not possible to say you have to stop here because it's a slippery slope, and things may end in a different way than you would have envisaged before starting the process. The example the author gives is about the registration in the gas. It's written, I won't read it, but it's clear that you begin with a registration, maybe you can arrive to a confiscation, although you didn't want to arrive to this point. The opposite argument says that it's not true, because we have to make a sound decision today, we have not to avoid the decision for the fear to draw a sound distinction tomorrow. But in the reality, it's not so easy to, I say, and I'm quite confident that it's true, it's not too easy to stop the things only to a certain point. Let's say it's a precaution principle, if you want, but it's what happens in the reality. This is the mechanism in a nice picture of the author. That is, you see, the camel sticks the nose in the tent, the monkey opens the floodgates, at the end you see a corn which grows into a oak. It's not a foreseen consequence, but it may happen. So really you have to be careful when you begin to do something. This is a nice consequence, but maybe consequences are not always so nice. The English and Wales case is very important, I think, because in the first decision was favorable to this automatic face recognition en plein air, and these are the features of the system. The automatic process, and also the Court of Appeal found there was no legal basis for the application of the system, for two reasons. Legal basis in the meaning that the law must circumvent adequately the discretionary of the power, and she found it was not adequately delimited for 2 points. The who question and where, that is the basic decision to be taken in order to put in use the system, were not clearly delimited by the law, and so the legal basis was not sufficient. That is, and also, consequently, there were no measures taken in order to face this challenge to the private life. This is so strong interference to private life. And one other point that you find very well described in this decision is the rustic bias, because they say that the system must be trained. It is trained, it depends on the balance of the population considered, of the people whose images are taken in order to train the system. And the judge said that the Welsh police had not done enough to be confident that the system were well trained, so he didn't comply with the obligation. They had to prevent this rustic bias, and so there was effectively possible that ethnic minorities could be defavored by the way the system was trained. So the point is always what has been said so clear, the relation between the individual and the public authority. This is the real point of the question. And that's why I asked an author if I could quote a passage of him. He didn't answer, but I did. And I will, for respect of this author, I keep silent and I read with you.
Thanks a lot, Mr. Bartoli, for this overview. I think when I was listening to you, I saw that filled with life what the EDPS said before, when he said the national data protection authorities will take a strong stand on this matter, and I think you demonstrated this very well. I'm also happy to see Dostoevsky at the end in an Eden conference. That was very enlightening. Thanks a lot. We come to our next speaker, that is Mr. Lorenzo Rinaldi. And there, with his presentation, we will go to privacy on the ground, or if you want, face recognition on the ground. I still need the microphone. Yeah, thank you. So Mr. Rinaldi is the head of the Electronic Investigations Unit at the Forensic Science Police Service of the National Police. Lorenzo has a strong background in biometric identification. He started from working with face recognition, then he worked in handwriting identification, and for 14 years, Lorenzo Rinaldi focused on fingerprints domain, starting from latent print identification in the AFIS system. Today, he's inter alia responsible for the Italian automated face recognition system. We saw it already on one of the slides, SARI, and for facial comparison activities. Please, Mr. Rinaldi, the floor is yours.
Thank you, Daniel. Good morning, everyone. After the two previous presentations, I would like to focus on the topic from another point of view, the one of the use of facial recognition technology by law enforcement authorities, especially in Italy. This is the reason why I would like to start by describing the most common use cases in using this technology in the law enforcement domain. The first use case is the border control cases. It's a one-to-one comparison between two faces assumed to belong to the same person. This is the case where a face image of a person is taken in a controlled environment, such as the automatic border control gate, and is compared automatically by face recognition engine against the picture which is retrieved from the electronic document. The result could be either authentication with some consequences or not authentication with other consequences. But let's put aside this case and focus on the following one, which is probably the most interesting one, which is the identification process. This is a one-to-many search against the database. This is the case where we have a photo, a facial image of an unknown person, notably a perpetrator of a crime, which is unknown, and we search this face against a reference database built over time by law enforcement authorities, made up of criminals, suspects, convicted persons, and so on. In this case, the facial recognition engine retrieves a list of candidates on the basis of the similarity of the faces, which is assessed by a trained operator in order to single out a potential candidate. Let me say from the very beginning that this is an investigation tool. There is no automatic decision nor action taken on the sole basis of the system, because there's always the need for further assessment. And here we come to the third use case, which is the facial image comparison. Here we enter in the domain of the forensic science. This is actually the comparison one-to-one between two faces, the face of an unknown person and the face of a known suspect. This is a completely manual procedure carried out by a facial examiner, a trained facial examiner, following strict procedures. And in that case, the result is used in court and is given against a reference scale in order to ease the comprehension of the result by the court. Let's add some background. This is the typical issue law enforcement agencies are facing nowadays due to the growing number of video surveillance cameras around publicly accessible space or private spaces. Because crimes are often captured by CCTV cameras, but at the same time, the perpetrator face is unknown. And what's asked to the police is to find a name for that face. Here we stand in front of a crossroads because there are two possible scenarios, depending whether we have a suspect or not. If we do have a suspect, we can run a facial image comparison, as in the forensic case. While if we do not have a suspect, we could search the face against the database. And this is exactly the reason why in 2018, National Police launched its first nation-scale automatic face recognition system called SARI, which entered into force in September 2018 after the positive opinion of the Italian Data Protection Authority, which allows searches against the National EFIS database, which contains the mugshot of criminal suspects collected by Italian law enforcement agencies by means of two artificial intelligence face recognition engines. The system allows in general three types of searches. The first one is the most direct one, which is a search by photo, which is called probe image. That means that we only have the face of the perpetrator of a crime, and we want to search the system. Then we have another kind of search in case we do not have any picture of the suspect or the perpetrator, but we have some physical description or other biographic data given, for example, by witnesses, such as nationality, height, physical characteristics. In this case, we can also search the system by those parameters. And we can also run combined search. This has proved to be very effective in order to filter out the result. In any case, the system retrieves a list of candidates based on the similarity, in case we have the picture, of course, which is assessed by a trained operator in order to single out a possible candidate on whom there is always the need of further assessment. Because as I told you before, this is an investigation tool. This is the typical result page where all the candidates are listed together with a score, which is an internal measure of the similarity, and the score is only a lead for the assessment. It cannot be used in court because it's an internal matrix of the system. But now let's see when those kind of systems are of use for the law enforcement agencies. This is a real case of a museum theft happening in 2018 in Venice, where a criminal organization succeeded in stealing some precious, actually, piece of jewelry from an exhibition in the Dodge Palace. The investigators were able to detect in the CCTV camera outside the museum the faces of two members of the criminal organization, making their recognition around the place. And with this image, used as probe image, the National Police was able, via SARI, to identify this person who had been fingerprinted in Italy 2 years before, after a theft. And this was a strong lead for the investigation, because after that, the investigators were able to identify the whole criminal organization. But now let's go back to the third use case, the facial image comparison, typical of the forensic science. I have to say that this is a very difficult task, because it's common sense that it's quite easy and straightforward to recognize familiar faces, such as family members, siblings, or famous people. This is okay, it's quite straightforward. But what if the face is not familiar? And we do work with unfamiliar faces, because same face may look very different under different conditions. And this is the situation where training of facial expert is key, together with strict technical procedures to follow. In Italy, we follow European and national guidelines to do so in order to build up the result. against the reference scale, as I told you. For example, those are the 19 facial image components we analyze when constructing and trying to perform the facial image comparison. Imagine that each of them is divided in multiple subcomponents that are always assessed. And for example, these were the most relevant facial image components of the facial image comparison made in the aftermath of the museum theft, which I have already described. Now, I would like to spend 2 last slides looking at the future, because, as it was mentioned before, we also launched that project in order to develop a real-time face recognition system named SARI Real-Time, which would be connected to a limited number of cameras and in a limited and restricted area, and would be able to compare real-time the faces of persons passing by in the restricted areas against a watch list specifically built for that investigation. In case the face would not trigger any hit, it would be deleted immediately and not processed anymore, while if it would trigger a match, an alert would be sent to a police patrol for further assessment. As Mr. Cannada Bartoli already said, in April this year, the Italian data protection authorities rejected the use of this system, which is, of course, is not in use. And this is the reason why I would like to end my presentation with, let's say with a challenge, because I know I am well aware this is a hot topic. I'm well aware, as the European Data Protection Supervisor already said, there is a lot of discussion at every level, globally, European level, and national one. And we are a part of this discussion. But as a police officer, I cannot help saying that under strict conditions, namely exceptions, under limits in space and time, and authorization from the judicial authority or other administrative body, and under conformity and technical constraints, the use of remote biometric identification system would be key for some, in particular, law enforcement tasks, such as the search for potential victims of crime, including missing persons, the prevention of a specific, substantial, and imminent threat to the lives of people or of a terrorist attack, in controlling the environment, for sure, as the security zone of the airport, in the detection, localization, and the identification of a perpetrator of a serious crime, such as in the search for fugitives, and, of course, in the post-processing of video footage in the aftermath of an incident or of a crime. Thank you.
Thank you very much, Rinaldi. So, I think your presentation brought to us the whole picture, because what we heard was the legislative situation, the regulatory view on face recognition, and you brought, Mr. Rinaldi, the view of law enforcement that tries to develop a system and then experience a ban. And as I saw on the end of your slide, you rightfully say now the system is not in use. So that is the situation that we have at the moment. And you also made the reference to the European Data Protection Supervisor opening the door in a hot debate on the use of biometrics and facial recognition. I would like to maybe go a bit more into the details of what are actually the next steps in this regard. But before I do this, I would like to ask if there's any question from the audience, because I know that we are already running out of time, unfortunately, but this is not our fault. We started late. But we have colleagues there with microphones, and I would like to ask you, who has the, please here in front, there's one question, and then there's another one, please.
Hello. First of all, thank you very much for the great insights. My name is Matthias and I'm working in security consulting, and I'm always very interested to bridging the gap between concepts and also the application in the real world, I would say. And so I would be very interested to hear about you guys. What do you think, so when we think about in the next 2 to 5 years, how realistic will it be to work with real-time and live data and also make investigations on it? And yeah, what would be your wish list from a policing perspective? Thank you.
Thank you very much for this first question, and I think it's for you, Lorenzo. It is the wish list that you would have for the next years.
Hello, thank you for the question. Well, I think these kind of tools, as I said, under strict condition and auditing mechanism, I think what we need is that all this technology should be auditable. But under those conditions, under conformity tests, I think that they would be a very powerful tool in the hand of law enforcement. Because at present, we face a lot of challenges in the search for fugitives, for example. Sometimes we do have the investigation lead that the fugitives could be in that area, but we have to deploy a lot of people, a lot of patrols, and it's quite challenging. If we could use, in this case, after an authorization, this kind of technologies, our action could be more effective. And this in terms of guaranteeing the freedom and the rights of the citizens. Because we already do search for fugitives. We already do try to prevent riots or prevent terrorist attacks. All these technologies could be a very effective tool for activity that we already do. I think this is my point of view from a police perspective.
Thank you very much. A very modest wish list, but I would like to highlight that you mentioned auditability of the system, which is actually a reference to the supervision of the system. If we look at the information that was given in terms of the discussion on the Artificial Intelligence Act, then also there we find exceptions. And if I remember, there was exceptions for serious crimes such as, for example, kidnapping. I wonder, Mr. Cannada, Bartoli, is this something you are looking now from the side of the Garante, also if you saw the slide of Mr. Rinaldi on the possible crime areas where exception could be applied? Because that is what we are talking now in future about. I wonder if you could share your opinion on this. Pronto. Si.
Yes, thanks. Yeah. No, the Garante has not yet analyzed in which cases it could be. Thank you. Garante has not yet been analyzed in which case it could be used. There is for data retention, the problem is similar. When shall we use data retention for every crime? But in this case, there is no reasoning in the Garante till now for which level of gravity we could use this technology. I think we have to think about but really we understand that it can be very useful for police enforcement. This is my personal opinion, of course, I cannot represent the official opinion of the Garante here, but really I think the most important thing to be considered is the cost for the general system. This is, I think, I think it's very dangerous to accept this per se, let me say this. per se. It's a question per se.
Thank you for this statement. I'm looking whether there are other questions at the moment. Otherwise, I would have one question for Caroline. Yeah, please, sir. Yeah.
Thank you. I'm just wondering about the current use of the SARI technology and how that aligns with what we've heard today in terms of the need for sort of specific legal basis for use of facial recognition. I understand that the use of live and real-time information was struck out by the supervisory authority, but how was that kind of decision-making factored into the current system that's in place?
Yeah.
Sorry.
Could you? Yeah.
I'll take the mask off.
We talk about face recognition, and
yeah,
the mask
sorry.
is very difficult.
No, it was.
Could you also introduce yourself?
Sorry.
Briefly?
Yeah. My name is Michael Armstrong from the Garda Síochána Data Protection Unit. So the question, sorry, was just about the current use of the SARI technology and how the legal basis issues that we've heard about this morning were clarified. Not the real time, but just the current reference database. Thank you.
Well, I'd start by talking about the technology. SARI is enterprise system. This is the name we have given to the standard solution. Is tested by NIST. When we started the public tender as a technical requirement, we stresses the fact that the old face recognition system, which is used deep neural network, should have been tested by an independent test organization such as NIST. While the legal basis of the system was well, after the data protection authority opinion, was that it was just only another kind of treatment of the same data, because we already used the EFIS database, the EFIS mugshot database, in order to search unknown person on the base of the physical description. So the system could retrieve the pictures, and it was just only another kind of treatment of the same data. This was the reason on the basis of the positive opinion given by the Garante.
It was a kind of office automation, let's say. That's the point. And this is not in open air, but it's something already at the disposal of the authority, of the police of the law enforcement authority. This is the point. Police enforcement authority already had and already were making this comparison between the faces. This is the point. This is the difference, I would say.
Thank you very much. I'm sure that there will be also during the network breaks the possibility to discuss again. Michael Armstrong is actually a member of the Law Enforcement Data Protection Officer Group, and I'm sure that we will have other possibilities to discuss this. We saw in between, a clip, coded bias, and that we had, sorry? More questions. Just one second, because I have a question for Caroline, and then we come to you. We had coded bias in between, and that was actually to provoke also some discussion from your side. Please, Caroline.
This is a very... It works? Yes, it works. This is a very important movie, and I had the chance to meet the realizer 1 year ago, and we had a debate. And to prepare the debate, I was about to talk about all the flaws in the European legislation. But at the end, when we talked together, she was like, Europe is amazing, you have a protection, what happened in the United States couldn't happen in your countries. So it's not exactly true, but what is really interesting in that reaction is that it reminds us that we have not the same legal environment that in code bias. So it's really important for understanding the dangers of the technology, but we also have this this legal environment which is more protective than this is in America. So we have some pressure for in the context of the global competition for AA, especially from the US and China. But the draft shows that we can build a different answer, taking into account our rights. And I also would like to add something we talk about very briefly during the presentation, is the place of third party, because there's not a lot of in-house solution on facial recognition, and we really depend on the technical operators and the industry. And most of the time, and the problem raised during the process in England we mentioned, these third parties are not willing to share the code in order to be audited or reviewed. And the industrial secret is very well protected in Europe. So this is also a big problem to fight against the bias they are mentioned.
Thanks a lot. Thanks a lot for reminding us of this, and also give the European spirit here, because at the end we have here a situation here on the podium is that we have a law enforcement authority and we have a processing ban. So the system of oversight works, that's clear. And what Caroline mentioned, indeed, Clearview is an issue. If we just look at this third-party product that is on the market and sold, and also to potentially law enforcement authorities. Stefano allowed me to accept some more questions, although we are over time already. Where are they? Please. Yeah. Oh, yeah. Oh, I don't see you all, but I see a lot of hands at the moment. Please go ahead. Here in Nora, please. Yeah.
Thank you very much. Nora Neela-John from the Institute of Advanced Legal Studies from the University of London. Thanks so much to the panelists for fantastic presentations on a hugely important topic. I wondered if they would share their views on the fact that the draft AI Act that the European Commission has put forward has made the assumption outright that real-time biometric identification is more intrusive than retrospective systems. And now that we have AI tools that are so sophisticated, retrospective facial recognition can provide a really rich profile of a person's previous movements, whereas real-time biometric identification will provide an immediate snapshot. It's still intrusive, but the retrospective use is completely overlooked by the legislation. So any views you have on that would be very interesting.
Thanks a lot, Nora. What I will do now is I will just collect the questions that are there now, and then we have a final round of discussion here on the panel. Second question, please. Yes, Juraj, please.
Thank you very much. Juraj Seifert from Vrije Universiteit Brussels. My question is about what you just mentioned, and the question is for Caroline and Daniel. It's about the use of Clearview AI, because recently there were a lot of media reports about the use of Clearview AI by the Belgian police, by Finnish police, banning the use of Clearview AI by their respective data protection authorities, and also reports that this use they were using was because Europol gave them the access or facilitated the use for testing or training purposes or something like that. So that's what we've seen in media reports, and I don't know what of that is true actually. So I'm just wondering if you could clarify the situation with the Clearview AI and what is the follow-up to all that, and what will in the end happen. Thank you.
Thank you, Juraj. I have to admit, for us, from an acoustic point of view, it's very difficult to understand the questions, but I guess I understand where your question went to. There was one other question I saw. Was there? Yes, please.
Yes, thank you. I was actually curious about when it comes, so you said it would be surveillance in limited areas, and I was wondering if you were expecting a phenomenon, just like with police patrol, where there's just a relocation of crime. And in that case, how would you stop this kind of slippery slope where there's just surveillance everywhere since crime moves to?
So if I understood the last question in the right way, you are asking for the limited areas that needs to be surveyed and not an overall coverage. Is this right? Okay, good, thanks. So we have 3 questions and we have a last round to try to answer them. The first question was actually about the retrospective use of facial recognition data, and I think Nora said that she thinks that there's not a lot of attention given in the legislative proposals on this one. What is the views? Can I ask the panelists? And if you would like to answer to one of the other questions, please go ahead. I don't know who wants to start. Lorenzo, you want to start?
Views. If I well understood, you mean the post-processing of the images. Well, actually, I think that in the AI Act draft, there is room for post-processing use, because I think that the very crossroads is the time for assessment before acting. This was, I think, a critical issue. If we use real-time systems, police patrol do not have actually, in some occasions, the time to further and complete assess the potential candidates or the dynamic, while in the retrospective use, in the aftermath of a terrorist attack, of an event, that should be the time for further assessment. This is I think it would be key. And of course, there should be technical safeguards, such as the clear retention time of video footage, something like that. So I would like to say that the European Commission organized together with the Slovenian presidency very interesting workshop, and this was one of the use cases described in the workshop, and I think this is the actual position in the AI Act from my point of view.
Could I ask again the question, please, because really I had some problem in understanding it.
Well, we had different questions. I think one of the questions was related to retrospective use of the data, of facial recognition data. That was a question from Nora. There was another question regarding whether the use of facial recognition data can be used for limited areas, I guess, by airports. That was the question, what would be our views? And there was a third question that was about use of Clearview data by Europol, and I guess that is the one that I should answer then, Juraj. That is my assumption. Okay, please, pick whatever you would like from these questions.
I'm not so confident about you to answer about Europol. Limited area, I think, yes, it's sure it's a fact. Sure it's a fact, and you know, with terrorism, it has been, I think, necessary, and I'm not so sure that the regulation is enough detailed, but and I'm not so sure it will be transitory. I think in limited area is a fact that we have to accept as it is, and we cannot. We have not the possibility to stop it, and I think it may be acceptable. Of course, it's a question until what point we can accept it, but it's a problem of reality. I think we have to take things the way they are until now, I think.
Thanks a lot. Caroline, your final statement in this panel.
Yes, so about the distinction between authentication and identification, especially in airports. Yes, clearly the technology is not the same and the use of data is not the same. So I can understand the difference of treatment, because the danger for me are not the same. But at the same time, what I'm concerned about is the deployment of what I call in law the regime consent. The fact that we deployed facial recognition based on consent, in our daily practice to the airport, from the airport to our iPhone, for instance. I think this is a concern because we won't be able, as we will be used to that kind of things, to justify the limitation that we can bring as far as terrorism concern or imply or that kind of thing. So the more this consent regime is developed, the less we can have the chance to regulate properly in the public uses, I believe, especially for law enforcement. And concerning Clearview, what strikes me most is how flourishing this society is today. After the revelation, we could expect that there would have been some sanction and that kind of thing. So they are procedure ongoing, but still they operate even better, and they have even more clients that they used to have before the revelation. And in a legal aspect, it reveals many flaws in our legislation, especially our definition of biometric data, which are supposed to be processed, and they are not always processed by that kind of society because they just gather data. So it's also a big concern. I'm waiting for the the European decision of the national data protection authorities on Clearview.
Yeah. Thank you very much, Caroline. Well, we come to the end of our panel, but of course I don't want to escape the one question that was more or less directed to me from Juraj. So just, I think most of you know, of course, what is Clearview AI. It's a company that gathered 3 billion images from millions of websites, including YouTube, Facebook, Twitter. Probably most of us will be in this database. I'm actually, Juraj, I'm happy that you asked that question, because I think the Eden network is also about responding when something is written in the newspaper, which might not be entirely correct. So for this, I would like to tell you that so Clearview is not used by Europol, has not been used by Europol, and is also not used via Europol by national authorities. So that is what I can say about this. So the news that was there, that we of course also see was wrong, but I'm happy also to discuss this further during the coffee break. Having said that, thanks a lot to the panelists, and I would like to invite you to give a big hand to the presentation that we received.